And if all my judges are set, all right. I'm going to begin this speech with two, not one, but two different workshop analogies, so bear with me. The first is simply, if it ain't broke, don't fix it. As we will be seeing, there is not a tangible harm to the status quo, not a reason enough problem in the system, to overturn military commissions. All of the harms that the affirmative teams could keep referring to can actually be solved under the current system without any policy changes. If it isn't broken, we do not need to fix it. The second workshop analogy is a bit of analogy with the Swiss Army knife. A Swiss Army knife has many functions: knives, screwdrivers, many more things. I can't name them all. And the fun things about a Swiss Army knife is that it has a few tools that you might use all the time, and they work very well for almost everything. But then, every once in a while, one of those odd bits or ends turns out to be very useful when you need it. I don't know, maybe you need to pull out the cork from a wine bottle. I'm not sure. The point is, there are some tools which it's always a good idea to keep in our back pocket. So long as it doesn't represent a harm to our safety or our security, we don't need to eliminate them. The ultimate argument and the ultimate philosophy of their affirmative team is that military commissions are an important tool to keep in our arsenal for combating terrorists and prosecuting for justice. And as we will see in today's debate round, it is best to keep them available both on the evidence provided by some of the sources quoted by the affirmative team and also by arguments provided by the negative. Let's first go to the first issue, which is about the disadvantage. My partner brought it up, how we're eliminating a valuable option. And this is going to refute the affirmative's last argument, basically how we have to show an advantage. I'm going to be showing you why this is in fact an advantageous system that helps us better prosecute terrorists. The first thing that we have to understand is that they have military commissions are designed for entirely different kinds of terror charges. Robert Farley explains this in 2010. He says that, quote, those kinds of parameters, McCarthy notes, take in a lot of cases that aren't international terrorists, but are often would-be terrorists who have, for example, been convicted of relatively minor offenses, such as immigration fraud or giving false information to federal authorities, or who have helped to finance a terrorist organization. Those may be important prosecutions in combating terrorism, but they aren't on the order of Guantanamo detainees. Unquote. What he is simply saying is that Guantanamo Bay is reserved for some of the worst terrorists, the actual people who helped lead these organizations in committing their violent acts. Federal courts are very well suited for prosecuting other terrorism charges, and in that sense, we use them, and we use them a lot. That's a good thing. But when you have these most extreme cases, that's where the Guantanamo Bay comes into play, and that's what we should reserve it for. Let's talk about some of the specific things which makes Guantanamo Bay and military commissions better suited for prosecuting these terrorists. This is going to be talking from the evidence from the Office of Military Commissions website, talking about some of the advantages it has. The first is rules of evidence. Rules of evidence. Each military commission consists of a military judge and at least 5 other members. Or rather, sorry, I quoted the wrong quote. But this is describing that in each case, the accused may be sentenced to death, a minimum of 12 members, and a unanimous agreement are required. That's right, I read the long card of evidence. That was just establishing what the court looks like. Going on to the next paragraph where it talks about the rules of evidence, it says the rules of evidence for military commissions meet domestic and international legal standards while addressing battlefield situations, and as such differ in some ways from the rules used in U.S. civilian courts. For example, evidence seized outside the United States may not be excluded on the grounds that it was not obtained pursuant to a search warrant. Similarly, statements of an accused are not excludable merely because the accused was not read a Miranda warning. Instead, the rules of evidence for military commissions focus on whether or not the evidence was reliable and probative, and if its omissions are in the best interest of justice, unquote. So what we see is that the rules of evidence for military commissions are tailored for battlefield conditions, dealing with some of the worst terrorists obtained under terrible conditions. The first is talking about the Miranda rights. It's basically saying in the United States courts, you have a right, you have to be read your Miranda rights before you can be prosecuted on those bases. The second is the idea of search and seizure, that there's certain rules about what evidence is and isn't admissible into a federal court. Those protections are fine to have in a federal court, but they don't always work for prosecuting the worst of the worst terrorists. In a military commission, we changed the rules to address the battlefield conditions. This demonstrates an affirmative advantage to possessing military commissions. Now, they brought up the issue of intelligence. We did not argue the issue of intelligence, but the issue of evidence standards is clear. Now, they also talked about how evidence standards changed in 2006 and 2009, essentially making the argument that these courts were reformed. I do not believe, however, this is the case, because I want to quote an example from 2009 where the rules of evidence prohibited justice from being served. This is the card of evidence that my partner did not get to address fully. From Danny Gonzalez in 2013, quote, in 2009, under the direction of Attorney General Eric Holder, the trial of suspect Ahmed Galahani was moved from Guantanamo Bay to the federal court in New York. Galahani helped to plan and carry out the 1999 U.S. Embassy bombings in Kenya and Tanzania. Due to legal rights and protections given to Galahani by moving the trial, critical evidence was made inadmissible. And as a result, prosecutors were only successful in convicting Galahani on a paltry conspiracy charge. He was acquitted on the more than 200 or more murder charges and a myriad of others. This case shows how vulnerable our justice system is to manipulation by Al-Qaeda operatives. End quote. So what we see is that even after these 2006 and 2009 reforms, which supposedly fixed the federal court system, people were still able to get off with hundreds of murder charges dropped by leveraging these standards of evidence against our own justice system. It's in these cases where using a military commission is more effective. Now, what is the impact to all of this? The first impact is that while federal courts have their advantages, they don't work in every case. Federal courts have their advantages, they don't work in every case. The second impact is that even the affirmative evidence recognizes this and doesn't advocate for abolishment. Even the affirmative evidence recognizes this and doesn't advocate for abolishment. My partner quoted Bobby Chesney, who said that it still is a valuable option that needs to be maintained. The second thing I want to talk about under this is that in the report that the affirmative team handed to me, we see that the report does not say that they should be abolished, and in fact, some of the people who participated in the report believe they should be retained. Quoting from the pieces of paper they handed me, quote, "Some members of the workshop believe that the military commission was a worthwhile endeavor when it was established. Some members also believe that the concept of military commissions, as found in the military law and historical practice, should be preserved as a future option for expeditious battlefield trials in theater." They go on to list a number of options for how they can make military commissions even more effective. So the idea that the evidence supports eliminating these military commissions does not hold. We can agree all day long that federal courts have a number of advantages and that the majority of criminals should be charged there. In fact, that's already what we do. We're only talking about the most exceptional cases in which there are advantages to presuming the federal courts, and even the affirmative sources agree to this point. The next issue I want to address is a couple of quick refutations to some arguments brought up in the last speech. The issue of lack of closure and the lack of due punishment. My simple response is that there's no harm to U.S. interests. Essentially, all they're asking for is vengeance. There's no harm to U.S. interests in any of these cases. The second response is that there's no guarantee that federal courts are in fact better. They use the example of how federal courts have charged 500 or so people and military commissions have only charged a handful. And they use that to say that federal courts are better. But my partner already responded to this by saying that federal courts on the large margin are charging smaller crimes, not applicable cases. In the big issues, federal courts are not as effective. And I already brought an example where in a federal court, a high-level terrorist was not charged. Ultimately, this is to say that there is, in fact, a reason to keep some of our tools in our back pocket. At the end of the day, we come to the conclusion that military commissions are a valuable alternative that is supported by experts and that does have advantages. We agree that federal courts are applicable to a number of scenarios and should certainly be used the majority of the time, but not at the expense of eliminating the military commissions. Thank you so much.